Everybody, we're going to have participants joining in, rolling in. We're going to give y'all time. As you do this, we're going to do the same thing that we always do and ask you to tell us where you are coming from. One of the most exciting things about this Lionsider audience is how international we are. So if you could just go over into the chat on the side, there's a widget button at the bottom. You can hit the chat and you'll be able to add your location. Just let us know where in the world you are, and we'll give people time to jump in. We're at 50 participants already, so I expect to see the locations jumping in. We've got New York, Arizona, Seattle, New York City, Los Gatos, San Francisco, Montreal, Arkansas. There you guys are. So give us all your locations. You're all around the world. I see some Toronto, Ontario's. Darlene, I don't know if you know that, but that's in Canada. You know, that's...
Yeah, familiar. Thank you.
Indeed. All right, everybody, welcome to this SaaS negotiation workshop. I want to talk a little bit about what it is to be in a workshop, what we're trying to accomplish with this event. Let me share some slides with you. We're going to use slides today, but just to let you know, you have the ability to minimize these slides on Zoom, to move them off to the side, to not have them be the principal thing in your view. I know for some of you that's really helpful. For some of you it's distracting. We're going to leave that to you, how you want to organize it. You can just move the screen around to fit your needs. But as we do that, I want to give you a sense of first of the other product, right? So as part of this, one of our assumptions with these kind of live events, these live workshops, is that you're not going to remember everything, right? There's no way that you can put all the stuff in your head and it all stick in there. And so what we always try to do is have a written deliverable that is robust, that is practical, that is tactical, that you can work with. And then in these workshops, we kind of dig into the nitty gritty, some of it's war stories, some of it's in my experience, some of the conversations that you can't really put down as well in a written product. So the two of them together are really what this experience is. I'm going to ask you to go to the same email probably that you used to make sure that you had your registration link. You should have received one from me either yesterday or since you've registered. And in that, there's a link to be able to download your negotiating SaaS licensing agreements playbook. So if you could go to that, we're obviously talking about more than licensing in this environment. We're talking about software agreements in general. But for this playbook, you're going to define your steps, your company's steps for negotiating these kinds of agreements. So please go download that. We're going to make references to it. We're going to look through it. The agenda and the goals for this workshop, as I mentioned, I think as we think about these kinds of events, we want to root you in the issue in the live session, to give you the opportunity to ask questions from smart people, including each other. And then when the time comes that you're actually dealing with the drama of some of these decisions, to go over to that playbook that we're going to ask you to work on and design in the interim. So we're going to cover a lot for the next 50 minutes or so. We're going to cover a lot of background, a lot of the key issues that pop up in these kinds of agreements, a lot of the red flags that Darlene sees in her experience. What I'm going to ask you to do during this period is to just freak out a little bit and document your freak out, right? Anything where you've got a question where you're like, whoa, I've never heard that before, or this is a problem I'm running into often, any of those kinds of questions, I want you to collect those as we go on. You can ask them in the chat. You can ask them and interact with each other. You can ask them in the Q&A feature, and we'll be able to respond to those in time. And then what we're going to do is during halftime, we're going to have an intermission in the middle to give us the ability to look through the questions to see which ones are most key, most relevant, and most answerable in this context. And we'll address those in the second half. In the second half, we're going to get a lot more tactical and really dig in, including into your questions. Darlene, I think that was all I had in terms of agenda. I want to talk about Darlene Tonelli. She is a friend and a superstar and a smart person, and these are my favorite kind of people. As I always say, if you're the smartest guy in the room, you're doing something wrong. And when Darlene's around, I am not, and I'm glad for that. So Darlene has been working in the media entertainment space for a long time and has built a firm in inter alia law where she is bringing together other smart people who are in media and entertainment and technology and software relevant to this conversation, helping in-house teams to be able to reach these agreements better. Darlene, I'm going to turn to you. Like I said, I'm going to give you the next 40 minutes or so. I will try to keep interruptions to a minimum, but I promise nothing. Yeah, Darlene, hi.
Hello, you can interrupt away. I'm always welcome your interruptions. And thank you everyone for attending, and thanks to Law Insider for hosting and inviting me to present. First of all, in the chat, if you're familiar with Zoom meetings, you can usually use emojis and things to react. I would love to have some mimicking of real life interaction on this webinar. So just in the chat, let me know, are you an in-house lawyer? What's your background? I'll just kind of watch them as they come in. But I'd love
Well,
to
and
know.
Darlene, on that, our good friend Josh, who was in the room as well, has done all the technical button pushing and has created a poll with just two simple questions. So to reorient you again, I'm going to ask you to put in the chat where you're coming from. That helps Darlene to know what kind of jurisdictions we're playing with here. But also, Josh is going to spool up a poll right now that's going to ask you two questions about your experience level and also your role. So if you could just take a second to answer those. Again, it helps Darlene to kind of orient the conversation to you all. So if you could just let us know what your role is in the company and your experience level with these kinds of agreements, I think that will really help her. And again, in the chat, let us know where you're coming from.
Okay, perfect. It looks like there are a lot of familiar cities on here, and I'm assuming for this purpose that most people joining this webinar are in-house counsel. You're dealing with SaaS agreements, but I'm going to probably target most of my discussion towards the provider side of a SaaS agreement. So obviously you can flip the hat that you're wearing into the customer role, but it's primarily going to be focused on the provider side. So this is all very helpful, and I will be interested to see what the poll results are. Are they going to come up real time?
Yes. Hi, this is Josh. I'm the invisible person here. So we're at 92%. I'm going to end the poll, and I'll go ahead and share the results so everybody can see and we can discuss them. Hopefully you can see those, Darlene.
Yeah, I can. Okay, great. Founder, excellent. Welcome. You're a key player in this webinar. Several a year. Okay. Perfect. Thank you. All right. So before I go, I'm going to go a little bit deeper into introducing myself so that you all understand why is Darlene Tonelli at Inter Alia Law talking SaaS to this group. But before I do, let me just tell you a bit more about the goals for this webinar. So number one, I think in-house counsel have an emotional connection to some of these agreements. We deal with a lot when it comes to SaaS. So we're going to talk about the black letter agreement, but part of the objective of a playbook is actually to minimize some of the surrounding drama of SaaS licensing. And I love SaaS agreements, just to be clear, but there can be drama, and the playbook aims to bring some of that down. So second, we're going to try to give high-level guidance on what the key terms are that you should be putting in this playbook. Also, what a playbook is, for those of you who don't have one or aren't familiar. And what we will not be doing is going exhaustively through and talking about the drafting. We're going to talk high-level points, which at Inter Alia, we find when we're discussing issues, even just having a discussion about it and flagging these things can kind of be enough sometimes to give you the basis that you need. So there are a number of resources on Law Insider that spell out where you can go for that detailed drafting assistance when you actually get into it, but that's not going to be where I'll focus today. My background is I started at a big firm, and then I went in-house for 8 years. And when I was in-house, I observed that what was really needed in the marketplace was a law firm where the lawyers were trained as in-house counsel. So effectively, that's what Inter Alia is. We are all lawyers with in-house experience. We focus on tech, media, and entertainment, and usually the intersection of those things in some way. And the interesting thing about us is that we provide day-to-day support to a lot of different companies. So in that role, unlike being an in-house lawyer at one SaaS company, we're seeing a bunch of different things across provider side, across customer side. And so what we bring to the table is that breadth of experience, but also with the in-house perspective. So when we do our work, we're a little bit different than a typical law firm because we're focused, as an in-house lawyer is, on efficiency. You know, you only have so much time in a day and you have all these things to do. So when we go in on a project to help an in-house lawyer, we're trying to make it work and function, and we're trying to make them look good in their job and excel at what they do. And so a huge part of that is coming up with processes that get the whole team on the same page, and then also trying to get the whole team to be a player in the contract process. And also to not have the same discussion over and over and over. So if any in-house lawyers on this webinar enjoy having the same discussion over and over about the same point in the contract, you may not find some of my tips useful. I have an allergy to having the same discussion over and over. And so much about what we do is to simplify the workflows, make the deal get through faster so that you can focus on the stuff that really shows that the in-house lawyer has value in the company. So that's the background on, and my specific experience is actually gives a lot of detail on why SaaS is so interesting to me. Sorry, Mike you skipped ahead, but it's okay, we'll get there. The one thing about SaaS agreements that is specific to, or why we're focusing on this particular type of agreement in this webinar. One is that these agreements, platform as a service, software as a service, they raise really interesting issues. They're often quite relationship based. They require a lot of trust going both ways from provider to customer. They are very focused on an understanding of the product. So I find that if there is a breakdown, it's because someone somewhere doesn't understand the product well enough, whether it's the vendor or provider side doesn't fully get their own product, or the customer doesn't really understand what they're buying. And so much of today's webinar is going to be about minimizing that effect. The other thing is that I really am interested in this area because my focus in my in-house career was on transitioning old world models into new world models. So when I started in-house, I worked at a record label, and our current product at the time was a CD that shipped to a retail store. So the entire business was built around that. And as everyone knows, around the turn of the century, piracy really changed that model. And my job became drafting agreements to license the copyright in that case in a new way, so that music was no longer going to go in a product box to the store. It was going to be streamed. And so what that led to was a whole bunch of figuring out all of these things that had to change between the old agreements and the new ones. Namely, you used to be in charge and know how many CDs you sold, and now you have to ask Apple how many downloads were sold, for example. So the whole concept of platforms, putting data into platforms, is something I find really interesting. And as well, for the purposes of this webinar, SaaS agreements lend themselves so well to a playbook. And we'll talk about what a playbook is in a second, but they really are a great test ground for a playbook where everyone in your company can get behind the strategy. So also for those who love boilerplate, they're a really great place to talk boilerplate. And anyone on my team knows that I love a new discussion about boilerplate so much. So we will talk about boilerplate in this at the very end. So stay tuned for that fun bit. Okay, now, Mike, we can skip to the next slide. I'm going to assume that you all have your ebook printed out. Oh, and one point. So SaaS, if you've got the ebook printed out, I'm going to refer to it from time to time. But before we jump in, SaaS licensing, just for everyone on this call, licensing is a typical software concept. So technically, a platform as a service, SaaS, software as a service, we're dealing with a subscription. We're dealing with access to a platform. We're not really granting licenses to make copies. So I just want to be clear that from a grant of rights perspective in your deal, you're not dealing with granting a license for copyright in a SaaS contract. However, there's so much about a SaaS that looks just like a license. So you've got restrictions on usage, you've got the scope of the license, you've got all these obligations on the provider and all these obligations on the recipient. So I'm going to sort of gloss over it and call them SaaS agreements, but you should be aware that when it comes to the grant of rights, you're not necessarily talking about a license. So that's a critical point to make in this. So we're going to talk about lots of licensing concepts, but we're not going to deal so much with the grant of rights section, just because it's not a key point for the playbook in this webinar. But I would suggest that you make sure in your agreements that you've got the grant of rights spelled out properly. A good place to look is at these sample clauses, but also, SaaS platforms that you're familiar with that have their terms online that operate similarly to yours. It's a good starting place if you've got nowhere else to go. Okay, so SaaS. When we're talking SaaS, we're talking about cloud-based software that's not hosted on premise. So in the olden days, 5-10 years ago, you would have the software at your company and you would have purchased a license to that box. It used to come in a box way back when, and it would be on your premises. You would be largely running the software. So this is a different world. We're talking about putting all of our data into a platform somewhere else. We're talking about a one-to-many type of model. And a SaaS agreement accordingly comes with all these extra points to think about. So if you need more background on the details of a SaaS agreement, sort of a quick primer on what comes up, I would take a look at page 5 of the ebook. And I would say that in this webinar, we are assuming a level of knowledge about SaaS. So we're assuming you know what SaaS is. We're assuming that you're working in-house on either the vendor side or the customer side of a SaaS agreement. So, if you are only procuring SaaS for your organization, you may find that you've just got to switch hats as you're listening. But if we assume we're all in-house lawyers trying to get a SaaS deal over the line, we're talking in this webinar about the 20%, hopefully, the major priority contracts. I always say there's sort of 100 contracts, 80 of them should slide through. They're not mission critical contracts per se. Maybe they're not heavily negotiated. Then there's 20 that are the big players where you either have less bargaining power or there's some reason why you've got to heavily engage with them as the lawyers. And so most of what we're doing in this webinar is going to be targeted at that 20%. So yes, we're going to use the playbook to define and have the right agreement in place. But then the playbook really shines on that 20%. So taking down the number of contracts that the lawyers have to spend a lot of time on and reducing the amount of time that you're going to spend on that contract. So, and reducing the amount of friction internally around contracts. So, definitions and key components are in the workbook. I don't know that we'll necessarily need to spend time on them, but I will say that you're going to hear a recurring theme, which is understanding the product, having good relationships with the team that manages the product so that you don't have surprises. That's the key. We don't want any surprises. So Mike's giving a reminder to use, I can't see the whole thing, but I think it says, please chat and be active. Is that what it says?
Yeah, and also, again, just a reminder, if you guys came late, during halftime of this, we're going to gather questions that we're going to use in the second half. So again, a workshop environment, it's a little more interactive. It's not just sort of one-to-many as much. So in the second half, we'll be addressing your questions. So please gather those for Darlene.
And please feel free to, put in emojis in the chat, like crying emojis when you're talking about dealing with the executive at the 11th hour on a contract or whatever issue. I would love to just have that kind of interaction. Normally, in the chat is fine. All right, so let's talk about the playbook. Next slide. So everyone is talking about the playbook. Everyone is talking about how everyone's got to have a playbook. And as an in-house lawyer, I think this is very stressful because you already have so much to do. And a playbook creation process is one of those things where it is short-term pain for long-term gain. And it's always hard as in-house to carve out that time to do the playbook. So, however, it really will hopefully save time if done properly in the end. So we've got to carve it out. We've got to be proactive, especially in SaaS, because as I said, so much of it is having the same conversations over and over. And what the playbook will flush out is a whole bunch of organizational challenge that currently is all being layered on the contract. So say your sales team is overpromising compared to what you can actually deliver. You know where that shows up? In the contract. But it's not really a lawyer or a contract problem. That's a business problem. So the playbook is going to get everybody around the table to solve those kind of problems. So I'm a sports fan. So I think of the playbook in its true sense, which is there's a team, everyone has a position. There are plays where everyone's got to play their position to move the ball down the field. Very simple. However, often a contract playbook is sort of pitched as it's something legal uses. Well, no, it's not. It's actually a playbook that goes from the start of the sales process right to the end. So you're forcing with the conversations around a playbook, it's absolutely critical to get the right people in the room. So you've got your overpromising sales team, you've got your finance team with their strict rules, you've got your executive that has a whole different set of strategic priorities that can vary from time to time. And you've got legal trying to sort of mediate between all of these different roles. What this is proactively getting around a table and saying, okay, what is our deal strategy? That's basically what a playbook is. And who's doing what? Very simple. It becomes a strategic asset. So just to give an example, I think most on this webinar can relate to. The way it's done currently is that sale without a playbook. So let's just say this is a pre-webinar contracting process. No playbook. Sales deals are coming in fast and furious. And my favorite is the sales deal is done. Okay. So what this will do with the playbook is to suss out whether it really is done. And one of the things that happens is that it's absolutely not done. No one's ever discussed half of the issues that are going to come up. And there's sort of an understanding in companies that, oh, well, that comes at the legal stage. Yes and no. You can solve for them earlier, and we're going to talk about how. But if you do this correctly, and you really give some thought to how you can kind of nail down the issues that arise at your particular company with your product, the playbook is going to fulfill a political role, not just a legal. So legally, let's start with the easy one. A playbook on the legal side is going to, increase consistency, reduce errors, make sure that you've got less variation across your contracts. It's going to serve as a great training tool for your new members of your team. Operationally, it's going to be excellent because people are going to be able to functionally know what the contracts say over time because they're going to not vary as much. But politically, and I think this is one of the most critical pieces of the puzzle that a playbook can play, is that in having the discussions outside a specific deal proactively, you're basically assigning responsibility for various parts of the contracting process. So instead of the pre-webinar scenario, pre-playbook scenario, which is typical, which is sales has done the deal, everything's done, just have to close it. It's just the last day of the quarter, just have to close it at legal. And then it's the first time that anyone on the other side has seen the accelerated payment on termination clause, or the first time that they've realized you don't give any more than 3 months of liability cap, etc. So these sort of material terms are coming up at this very 11th hour. And what that translates to politically is, oh, we had a deal over here in sales and then legal crushed our dreams, basically. So I think that a playbook can help solve for that. And it also makes it possible for legal to have the parameters such that you're just communicating what the company has decided with you as one input, one member of the team, as opposed to, legal has decided the risk is too high. That's actually not what's happening, but it can be what's perceived by the whole company. So instead, what we're trying to do is to have a process, and this, I talked about this a bit for anyone who was on the first webinar. I talked a little bit about how the sales document should go through all the way to the end contract with consistency. And if we can get that to happen, you can avoid really simple stuff that just stops so many deals. So simple example, you are, and I'll use this example throughout because it's a great one in SaaS. You are selling a security monitoring device. So if your sales team is selling a burglary prevention device, you've got a problem at the contract stage, because the other lawyer is going to say, you're supposed to prevent burglaries. Where are my performance guarantees? Do you prevent 95% of burglaries or 100? What's the guarantee? Instead, what you're guaranteeing is your monitoring, and you're promising that you will monitor, you're promising you'll catch certain things, et cetera, et cetera. And if you carry that through, you should get stopped at the contract stage less often. Mike, do you want to interrupt? When Mike starts nodding, I'm like, oh.
Maybe I'm just agreeing. I was just, sorry, I was thinking about our last conversation and the phrase that I often use, which is it's easier to manage paper than people, and nodding my head at the political point. But no, sorry, go on with your example.
Okay. So that's the key thing that happens, I believe, with the playbook. So you're, and not to make a joke, and no offense to anyone, I think literally the most fulfilling thing about working with companies the way we do is when the sales team and legal get on the same page and start rowing in the same, let me just mix all the metaphors, moving the ball down the field together, rowing in the same direction. Like, it's just so rewarding. And the sale, it's sort of like, it's great. It's a good feeling. It's way better, much preferred to this, which can happen. And, sometimes it happens, and I'm going to just out this problem, put it out on the table, is it happens sometimes because the sales team is not doing their job. And so it's an easy one to be like, well, it's not me. I'm doing the sales. I got the sale. But then over there in legal, you're like, you didn't do the sale. And if you're only having that discussion on the last night before the deadline, you're doing a couple of things. You're reacting, you're giving them cover, because, it does appear to everyone else that it has died at the legal desk. And then you're forcing your decision makers on the executive side, so the founders on this call, you're forcing them into a position where they have to agree to something that they don't, either get the deal or agree to too much liability. That's it. Those are your options. Those are terrible options. So instead, we're going to do a playbook, and we're going to get this out on the table. We're going to get our deal process to be a strategic asset for the company. So let's skip to let's assume we've all bought into the fact that we need a playbook. Just first of all, because we're on this webinar. Second, because of the points I've just outlined. We do see these across so many companies, and this is why I feel really confident talking about it, because I think when you're an in-house lawyer at one company, you might think it's you or it's your company. I really believe this is an industry-wide problem that we can help solve. So here's how we get to the playbook. So the ebook, sorry, these terms are confusing. The ebook is going to give you some of the guidance that you need just to get started. Sometimes half the battle is just getting started. So the ebook has the guidance, but then getting to actually doing the playbook is going to be the next piece. So the first thing I would say, and this is maybe controversial, but I think it's really tough to do a playbook without having negotiated a few deals for the company, having a few road tested experiences. Really tough, because you can pick up a contract and say, okay, here's some issues with it. But until you really have gone a few rounds with the other side, you don't really know what people are bristling at in the contract. Example, sometimes when I go in, a couple of things happen. Sometimes when I go in, there's a contract, it's the template or the precedent or the standard terms. And we get into a negotiation, and I realize that the contract has nothing to do with how the company does business today. So we're arguing about all these things that aren't even the way that the company does business. So that problem can be sorted in a playbook, because part of the discussion with the team is understanding the product, understanding the business needs, and we'll get into that. Second thing that can happen when you're negotiating the deals is you really get up close and personal with the actual problems in the deal. So what I call a speed bump. So a speed bump, like in a road, is always there every time you cross the road. It's the same bump. You go over it every day. And so many of our SaaS agreements have a speed bump in them. And if that speed bump is important to the company, we have to figure out how to deal with it at the playbook stage. So if you haven't negotiated a few deals, it's going to be hard to do the playbook. However, you can start with a bare bones playbook and not overpromise what the playbook is going to do. You just start collecting things for your playbook. And then as you understand the company better, you continue to iterate on the playbook, making it better. So do a few deals, then get everyone in a room that is critical to the deal and have a discussion. It doesn't have to be in one room per se, but I do think it works best when it's a group process so that everyone at the table can see the different interests in play. Because a lot of this stuff is just about sales has their interest and legal has their interest and the founder has the interest. And sometimes they're just different interests. Certainly sales is often compensated differently than legal. They have different objectives. Legal's compensated for preventing risk. Sales is compensated for generating revenue. Those are not compatible. So having everyone around the same table, to me, is a great way to have empathy, really, for what each person in the whole equation is dealing with, and to assign roles. So here's a key point about that. Back to how legal is only one member of the team. This is of the contract team. It's often not perceived that way, but that's the reality. And there are so many things so you say you identify a speed bump in your negotiation, you can have sales become an ally in fixing that speed bump. So for example, it could be as simple as explaining it better in the sales materials. It could be introducing it earlier in the process. It could be sharing an annotated set of terms earlier before it hits the lawyer's desk for the contract negotiation. It could be empowering sales with a few fallback positions so that they don't have to come to legal as soon, things like that. So all of that stuff can be fleshed out. And depending on the group, you may have and what I have found is there are varying degrees of comfort with contracts and negotiation in every company on every team. Some companies have sales teams that are excellent at contracts, and we should definitely figure that out early and deploy that in, to help the lawyers get the contracts done. Some sales teams are less good with contracts, and that's okay too. Then we figure out how they will help. Maybe it's just getting them to send out documents that also match the contract. It can be, you work with what you have. And I think that a single message throughout this should be that, we're not aiming for perfection, we're aiming for improvement and ease over time. So in the workbook, ebook, we've got two sort of threshold worksheets that are really the key questions. One is a strategic assessment about your company, because the playbook is about your company. So we're not going to present a playbook that everyone can use for SaaS, obviously, but we are going to present the tools to figure out what you might have to do with your playbook based on your company. So the strategic assessment talks about, what's your company trying to do? Are you planning an exit? Do you need revenue? What are the objectives? I have found it's just so much easier to negotiate and protect interests if you know big picture what the company is trying to do, not just small picture, what's this contract about. So strategic assessment with the group around the table. Next point is the risk assessment. So you're looking at, what are the real risks that this company is facing? And honestly, if we go to examples, if your company is planning to be acquired within the next year or is going out to market to look for a buyer, you're going to need to have a clause in your playbook that is pretty focused for change of control and assignment. Maybe that clause is not as much an issue for a company that's not going into an acquisition phase. But it would be great if, rather than discussing it with the executive the night of the deal, you put that in your playbook. You're like, hey, oh, great, you've identified that there is this exit coming. Does this clause work, do you think, for the strategy that you're planning? And make sure that it does, because that becomes very important. If you're selling a business because of all these contracts, you've got to make sure that they can go with the business. If you can, they're not going to be, again, this assumes perfect bargaining power sometimes when I make the point, but that would become a playbook issue. And as you'll see in the ebook, you're building out your playbook with fallback positions. So you're actually saying, our ideal is a change of control provision that says we still get to keep the contract even if we change control, or we can assign this contract even if the ownership changes. But your fallback position might be, okay, we can terminate if we can't, deliver, or, whatever the issue is. You've got a plan A and a plan B. And then I always have a third column, which is like context for why you are having that position. So, we need this because, and depending how widely used the playbook is, that is a critical component, certainly for education, but also just to give context that will help you negotiate the point. Another example, and this is a real one that we hit quite a lot, actually. The example is the company needs to do the deal or it will not be a company anymore. This is a real scenario. And I find it shocking how, it doesn't really come up unless you're all around the table sort of with the full facts. If the deal has to get done, then the playbook can be more flexible. And then you can revisit it next year. Once you've got the revenue solidified, then come back next year and get the risk down. But for this year, we got to get revenue. And if we all agree around the table, and the lawyer's job, obviously, as we'll discuss in the second half, is to make sure that when we go to get the playbook terms for the strategic objective, they make sense and they're the best we can get in the market. Those are the examples. So you're dealing with your own company, you're doing this strategic assessment, you're looking at the actual risks that your company has. And then the other interesting thing that you can do in this is really look at how the business can put things in place to protect against these risks as well. Because if your contract is the only place you're protecting against risks, that's probably not going to be enough, especially if you don't have a lot of bargaining power to reduce risk that you're taking on. So insurance can be secured sometimes as a risk mitigation measure. We'll talk a little bit later about privacy by design, sort of cyber security by design. There are things on the business side that can also be done and probably should be done. The playbook discussions will flesh that stuff out. And finally, this is the one, and I don't want to get too into the weeds on this because this could, so many points in here, could be their own workshop, but legal design. I put hashtag legal design kind of as a joke because it's something that a lot of people talk about, but yet I find don't notice it when it's happening. So I think legal design is a critical component of all of these deals where you're trying to improve a deal flow. So for example, your contract, I've come into situations before where the client identifies a problem with their own contract. And then I look at the physical design of the contract, and the problem is like, that clause is in almost bold as like the second paragraph on the first page. And I'm like, the problem in the contract is that that's an issue that keeps coming up and getting negotiated into a position that you don't like, but you're presenting it from a design perspective as a critical issue, and it's just begging to be negotiated. Whereas I think you can ease someone in to the solution by introducing it earlier and doing all of these things. And then just from a design perspective, putting it in its correct place. So for example, if the issue is an accelerated payment clause on termination, and that's something that you're constantly tripping over in the contract, don't give it its own subheading called early termination payment contract paragraph 2. First time anyone's ever seen it is right there in the contract. Of course, it's going to be heavily negotiated, 100%. So move it, put it with the correct spot, the termination provision or the payment provision, and then work with your sales team to make sure that the pricing as communicated is clear, that this pricing is based on a 3-year term. We are amortizing the cost for your convenience, but here's how it works. Anyway, I'm on the legal side, not the sales side. So you'd work with them to figure out how they communicate it. But the point being that if the first time anyone's seeing this painful point is in this like bolded, ugly section at the beginning of the agreement, you might struggle. Similarly, when business terms are willy-nilly through the contract, that can affect the negotiation because everyone's piling into the contract to look at the business terms and the legal terms. So their business team, their legal team, everyone's messing around in the contract. You can sometimes solve for that a little bit by moving the deal terms up into the first couple of pages, for example, the business terms, and then leaving the legal terms more on their own. And when it comes to legal design, you can do similar things within the actual contract that will solve for some of these problems that you've identified. One of them is you can just put I've got a couple of situations where the product is complicated. And so the business and the sales, the customer that's purchased the product, they get it. They've been involved in a long sales process, but the lawyer on the other side may not get it. So I have sometimes just said, listen, your contract is so doesn't easily express what your product does. Let's do like a quick intro for the lawyer that just says, in lawyer speak, this is what this product does. This is an intro to this contract. You will note the following, and sometimes even just call out some of the issues that they might trip over without understanding the product better. So that can be just a huge smoother of the negotiation. One thing I saw once, which I thought was brilliant, was a company that had probably 80% of their contracts sailing through on standard terms and 20% negotiated. They had a full-on set of terms on their website. It was an annotated agreement where they had said, here are our terms. And there were all these comments that were like, here's why we asked for this. We asked for this, although it's not standard, because we have this particular feature of our product. And it was really helpful. And I thought, I bet they don't have to have that discussion 50 times a year, because there's the answer right there. They can direct people to it. So the format of what we're building here, you can go with whatever format is going to work in your organization. It can be an annotated contract if everyone's working with the actual contract. I like the playbook because it's a bit more flexible on identifying the key points and not kind of getting lost in the forest of points. But overall, what you're aiming to do is to just make sure that, your job as the lawyer is partially to help get the contract done. And the way that the contract looks is part of that. So hopefully that's not too out there a concept, but I really think it is. Someone's got an easy contract to read. I think it's a strategic advantage. And there are movements. Obviously, a lot of large cloud providers are putting 2-page contracts out there and things like that. So I think it's not.
Can I ask a question real quick? So, Darlene, we're about to pivot to some of the key considerations in software agreements when you're making these decisions. Before we do that, this is maybe driving home a point that everybody in the room already agrees on, but Paul asked in the Q&A a smart question, and I'm going to ask the dumb version of it. When, if you're in this situation and you've got an outbound contract, it's your company's contract, this makes you money if the contracts get signed. We run into them often because it's to sell our product. To me, it seems pretty obvious you need a standard operating procedure, right? You need a playbook. People need to know what they're agreeing to. But Paul makes the point that, a lot of times his clients, these are inbound contracts. They're happening a few times a year, or he's at a later stage where people are fighting about something that didn't happen in a contract. As sort of a threshold issue, what are the considerations that make you say, there are people who think you should have a standard operating procedure for taking the trash out, but most in-house counsel, they don't have time for that. It's not high impact enough, whatever that means. What are some of the considerations you think drive, we should sit down and make this decision before we get to these decisions?
So I think that a playbook can be useful for any side. The challenge with external counsel is it's hard to just wade in for all of the reasons that we're highlighting here. It's hard to wade in with the stuff that really reflects the business reality, with the comments, with the, how can you possibly just review a SaaS contract out of the blue without a decision or a discussion in advance about what the client's trying to do. Obviously, every lawyer is going to do that due diligence at the beginning. So, in Paul's case, maybe what would be most helpful is, like a checklist of key questions that you're always going to look for. So maybe start as part of your playbook with some version of this, which is ask the client, like, what are your key strategic goals? What kind of risk assessment mechanisms, or what do you have built out? And then maybe you take it more like a checklist. So you would also possibly have your playbook built out where, depending on what side you're on, it's hard to flip from vendor to customer. It is, but you can definitely get that organized in a checklist format. That's
sure, but at minimum, I think we can say, so if you've downloaded this workbook, this ebook that we sent you, that is to build a playbook, you may be wise to adapt it to your particular situation. If this is the kind of contract you're not seeing a lot, it's not high value to you, if it's not high risk, to Darlene's point, it might make sense to drive this to a checklist as opposed to a really long, elaboration of your purposes. So I appreciate that background. Let's get to what's important for software itself.
All right. So, okay. So the first bit, we've talked a lot about where you recruit your contracting team into the process. So you're looking at how do you get people around the table? How do you suss out all the business issues, make sure you're addressing them, and really try to laser focus on the issues that have to be captured in the contract. Effectively, it's an elaborate way of getting instructions from your client and creating sort of a central hub where you can go back and revisit those instructions. You're probably already doing that today a little bit with your template updates, but this is sort of a bigger picture scenario. And we do talk in the ebook about the process of updating the playbook once you've built it and iterating over time. But key to this discussion is going to be the bits where the lawyer adds the value. And obviously this is probably where we're all living today. I think when you're in-house doing SaaS agreements, you're just living in the indemnities, reps and warranties, liability caps, and honestly, it can be fun and it can be horrifying. And I think we're trying to come up with ways to just minimize the strain of it. So the key points and the places in the deal where I think that the lawyers, as opposed to the business, add a lot of value. One is clarity. So bringing clarity into the process. You are very skilled at drafting. If you understand the product really well, you can help to get the product explained well in the documents. That's number one. A clear definition of what the SaaS offering is, what you get, what you don't get, and also sort of putting the team on notice that they have to keep you updated on what the product does. Because the worst case scenario is when you find out that your product, there's been a huge product change that no one told legal about. So getting this routine discussion with the team helps minimize the risk of that happening. And if you're clearly defining what the product is, you're helping all of the departments, frankly, especially sales, to have no gap between sales and legal, or minimize gap. Second thing is, and this is also a sales point, if you're drafting around extra charges and usage fees, anything like that, anything where there's sort of a discretion on the provider side about how extra fees work, I think the lawyers can be really helpful there, because many disputes come up over that type of issue just because it's drafted very poorly. And it can be clarified. And I find that just understanding how the clients do their usage measurements and charging it's tough, and it needs to be explained and well understood. So lawyers are helpful there. I think a critical spot where lawyers can be extremely helpful is in cash flow protection in the agreement, namely dealing with invoices that are disputed, early termination fees, as we referenced. And then also when it comes to cash flow, I view remedies as a really important point when protecting cash flow and revenue coming in on deals. Because if you are really clear about the remedies, you're reducing the risks of things like just non-payment because something's happening that the customer doesn't like. So we'll talk about that in a bit more detail. Data security, obviously that's lawyerly stuff, and we can add real value there. Reps and warranties, we can add real value. And then again, dispute resolution. How do you solve a problem when it comes up? Those are the places where we're going to, I think pretty much every playbook has to address those issues, in addition to other specific business points that you may have. So let me see, can I get into these before the break? Let me talk just about invoice dispute resolution quickly, and then we can save the rest for after the break. So many times I see a provider agreeing that the customer only has to pay an undisputed invoice. So to me, that's just such a recipe for disaster. And it's like the most mission critical piece in a SaaS agreement is that the payment from the customer goes to the provider. But yet so many agreements have this, oh, well, if it's undisputed. So I like to do a couple of things. And I think that this is an area where lawyers can really help the customer. Just set some parameters around the dispute. So one, you can't dispute the fees that are already agreed. If there's a dispute about the usage fees or any sort of additional fees, fine, you pay the ones that aren't disputed, and then we discuss and we set up a process for dealing with those, that disputed bucket. And when you get in there, I also, ideally, if you have enough bargaining power, try to indicate that the disputed invoice process is not the way to deal with a breach. And so if you can keep this clear in your agreements, it will be very helpful. But often there's a problem. There's a warranty section that says what happens if there's a breach of the warranty. Maybe it's a repair or replacement. But then the customer is just like, I'm not paying because it's not working properly. Like, well, no, that's not an invoice dispute issue. That's a warranty issue that's handled over here. That's a really critical lawyerly piece. So if you can make it, look at all the terms that go around the cash flow and make sure, like sort of fast forward into the dispute territory and think, where is this problematic for my client and how can I add value by fixing some of these things? As long as you recruit the finance team to actually deploy the dispute resolution process as it's envisioned, it can be a great way of sort of containing issues and making sure that you're dealing with them sooner rather than later. So yeah, let's pause there because the rest is going to come out in the next bit. How long do you want to take for a break, Mike?
Oh, sure. Let us take a break here just for a few minutes. And there's a couple reasons. One is because I probably need to let the dogs out. So if you need to let the dogs out, but also to give everyone a moment to ask the questions that have been on your mind. We're going to get into the nitty-gritty of these software agreements. If you've got questions about data security, about payment terms, about dispute resolution, this is the time to gather them. If you put them over in the Q&A, we're going to use those to guide a lot of the conversation in the second half of this workshop. And we really want you to drive that. So if you will just take, it is currently 12:54 Central. If we can come back at the top of the hour, which is 6 minutes from now, I will work to gather as many of these questions, and Darlene will look at them as well. We want to give you guys a chance to be part of this conversation. So does that work for you, Darlene? If we just gather questions for the next few minutes, we'll review them and then let the dogs back in.
Yep, sounds great.
Okay, we'll just take a break here for a few minutes. You guys start gathering your questions. You can use the Q&A feature. That would be the easiest way to do that. If you see that down at the bottom, just let me know if you have questions in the chat. And I'm not sure if you all can see these questions, so I'm just gonna, to keep us entertained while we're sitting here for a few minutes, I'm gonna ask some of these questions out loud and give you a preview of what we're gonna be answering later. Paul Shelton asked, I've seen some relationships sour into litigation when a client wants to transition from SaaS to their own in-house system because of cost and need. So that transition is it's an interesting contract negotiation moment. Alex asked, what software, this is a good question, what software have you seen out there that does a good job of creating and managing playbooks for your contracting process? So is there someone we can copy that's given us a view into their legal operations? You know, we could talk about that for a while, but a lot of that is just now becoming public, that companies are sharing how their legal operations work. Mike Loftus asks, how does one best factor in upfront payments for setup and integration, given revenue recognition rules and separating it from the monthly SaaS license platform fees? So that's an interesting substantive question about negotiating the setup. Let's see, this is such an interesting question, and I don't know if this is one I've been wrestling with. Anonymous attendee, I don't know, is asked the question, isn't the idea of a playbook or some educational program for the sales team, which internally informs the sales team as to what the certain, this is such an interesting question because we have used the term playbook in this industry to mean everything, right? And I could say, as we've thought about using the term playbook in our trainings, how are we thinking of playbooks, right? Is this just a spreadsheet with different positions on it? For any of you who have ever attended a training that promised a playbook, that's probably what you got. You might have gotten an Excel spreadsheet. And as my buddy Casey Flaherty would explain to you, there's no tool that lawyers understand less than Excel spreadsheets. But you get to deliver these Excel spreadsheets, and you're supposed to make decisions with them. Sometimes, to your point, it is a tool that is given to procurement to say, this is when to call us, when not to call us. For the sake of this conversation, just the way we're thinking about it, we think about it as a knowledge management tool, as a standard operating procedure, as a way to make decisions outside the context that you can revisit later when you're in the context. So just for your information, when you download our workbook, the playbook that we're trying to lead you to design for your context, the workbook has a bunch of information about these kinds of agreements, where the red flags are. It's educational, right? Because again, we're thinking of it as a knowledge management tool. There's a lot of background that's given on these kinds of agreements. There are worksheets where you're going in and asking yourself guided questions. So this is an audit, really, of your current processes. And then it is a tool to help you design another thing called a playbook that will document your standard operating procedures. So I don't know if that answers the question, but it is an interesting question what the heck this word means when we use it so much. I just did the lawyer thing and defined a word for 10 minutes. Christopher Cantor asked, any tips or tricks for renegotiating existing contracts? One of the areas I've run into is bad contracts have been negotiated in the past. Any thoughts on going back to improve terms within finalized contracts? Really interesting with software as a service, to your point, because those things go on forever, right? Where it used to be you buy a software and every time you're going to buy next year's software, buy the update, you go back to the vendor, or if you are the vendor, you have a renegotiation of the deal because every year you've got this bundle of updates. What do you do with SaaS when the updates are constantly happening? It's a good question. On payments, what are the thoughts on detailing the invoicing process? What are some of the best practices for languages around electronic or automatic payments? A lot of questions about payments. Michael Loftus asks another item I see often, the inclusion of links to the additional terms and documents instead of having them codified in the agreement. That's one we've talked about on the Contract Teardown Show a lot. We get kickback demanding the terms be included in the agreement in full. How do you suggest managing the balance between a full-length fee agreement versus shorter form documents with links and external items? These are all really interesting questions. We've got about 1 more minute. If you all want to ask any other questions, please use the Q&A feature at the footer of Zoom. Ask us any other questions you've got. It looks like I've got one in chat from Jacqueline. What is appropriate to rep and warrant versus just promise? Example, is there a meaningful difference between stating each party will comply with applicable law versus rep and warranting the same? Good question as well. Please take 1 more minute, let the dogs back in if you need to, and ask any other questions in the Q&A. We'll start here in 1 minute. All right, Darlene, I'm going to ask 3 more questions that we're going to be able to revisit, but just to read these out loud. What format would you recommend putting the playbook in? Ours is currently in Word and looking to revamp it. Oh my goodness, anonymous attendee, you are nailing the problem. You know, I'm a Kanban board fan. Somebody asked me what my favorite legal tech tool is, and I always say a Post-it note, but that's probably not the best way to put a playbook. So that is an excellent question about formats. As a client for SaaS, can you give an example of what you would playbook as preferred and acceptable or unacceptable for IP infringement? So it's a good question. We're going to get into that in a minute. Darlene's going to dig into the details. So how would you categorize these different, if you're talking about IP infringement, what's preferred? Would it be nice to have? What's a deal breaker? David Shirk, handle termination and access to historic data so that it doesn't become voluntary ransomware. 1 more anonymous question, Darlene, and then we'll get started. What are best practices for cross-checking whether the language in your contract will bump into litigation based on state case law? All right, we're going to dig into these questions and many more. I appreciate you all sharing them. Please continue to share in the Q&A. I've got a couple more questions that are popping up in the chat as well. I'll look over those. Darlene, I'm going to give you the floor. Do you want to go back to the data consideration slide before we move on to the next questions?
Okay, I'm just going to try to, that's a lot of questions. That's great. So I'm trying to figure out if I should just answer the questions or go to what I was going to do before. So why don't I'm going to answer in the course of my presentation, the one about the IP infringement indemnity. Definitely going to answer limitation liability unique to SaaS. We can talk about just Mike's question about the links to external web pages and things like that. That is a contract design issue for sure. And so if I have time, I will talk about that one. Renegotiating existing contracts. That's such an interesting one. I think you can, is the short answer. I'm going to deal with that one first, and then I'm going to deal with the playbook for sales question quickly. So, Chris, renegotiating a bad contract, I think you can do it. We do it fairly often. It is just something that as long as you've got a lawyer on the other side, sometimes you can wade in. Where it's hard is if you're midterm or there's nothing new happening. Very hard to just wade in with nothing for leverage on your side to renegotiate points. However, I think that, you know, if you've got an uncapped indemnity in a contract that sales negotiated, first thing is to let people know that that's in there. Maybe, and I've had this discussion with clients before, sometimes you might have to terminate it because it's too much risk for the reward of the contract. So you look at the termination provisions. And sometimes you've got to come up with an offer to incentivize the other side. So those are business solutions. I find that building a good relationship with the lawyer on the other side and just saying, listen, like this was negotiated in 2005, the market has changed. This indemnity is not market. So maybe we can, you know, discuss for claims prior to this year, set a limit, but then going forward, we want to move to market terms, which are, you know, whatever they are for your industry. And I can talk about it. Anonymous, your question about the annotated contract for sales. So I have also seen, and this is kind of my point about the way you need to use the playbook and the format that it takes. I have seen clients that literally take the contract and beneath each section number, they spell out why we have this. Can we move on it? Why not? If you need to move on it, please contact so-and-so. There are really basic annotations that are prepared for sales. And then in the playbook that I'm talking about, which I like Word, Mike might not like that, but I like Word or Excel. I can use Excel, or a shared document of some sort with the key players on the team. But the concept being that you are spelling out the items that people have. And sometimes in a playbook, if sales is involved, you can allocate roles and responsibilities to that item so that sales is responsible, or finance is responsible, or IT is responsible. And they are in charge of updating the provisions in the playbook. Of course, we all know that often it's the in-house lawyer who wrangles that process together. But depends really who your sales team is and what they need, really, and where you're encountering the problems in your company. So a typical playbook really takes the form that your company needs it. And yes, there are lots that are directed at sales, but I don't find that just explaining to them this is my own experience. I don't find that just explaining gets the whole job done. I think it gets you part of the way there. An informed sales team can be helpful. An informed sales team can also be very dangerous, depends who's on the team. And so that's why I think that you can use the format that makes the most sense. Okay, let me talk about cross-checking with case law. So I think that once you go through the strategic assessment, the risk assessment, if you're really fixed on a certain outcome and you've got to get it right, I would get the research done or do the research on the case law for that specific indemnity or issue that you're dealing with, especially at playbook stage. You don't want to be doing it every time you're negotiating a contract per se, but when you're doing the template or you're doing a playbook, that's the time to identify issues where you need additional guidance. So, staying on top of developments in boilerplate, my favorite, that's key. Interpretations of clauses, indemnities, seeing what's going on in these types of contracts is obviously part of what we all have to do, but hard when you're in-house. So checking in on that type of stuff each time you update the playbook is at least a good way of making sure you're doing it annually and that you've had advice on that clause recently. So if there are mission critical clauses, it's tough to just give the whole contract to someone and say, hey, does this comply with all the case law? But you can identify specific issues. That's what I would say is like the best practice for cross-checking. There's so many issues that come up in these agreements because sometimes you get to the 11th hour and the other side wants to change the governing law, which throws all of that into debate, but it can be a playbook issue. Maybe you never agree to change governing law for that reason. All right, let me just jump in. I'm going to touch on a few of the other ones that I saw during the break. If there are new questions, I may not have seen them, but let's talk data security. So returning to this point of how does in-house counsel identify in the playbook key points where they can add value? Data security is one where whether you're acquiring SaaS or you're providing it, you're going to be a critical issue is what are you doing with the customer's data? So one problem I see in a lot of agreements is like a mélange of these issues. So data and confidentiality, confidential information, PII is all kind of blended. So if it's helpful, even just for our purposes today, just to break them out mentally and deal with them each appropriately. So there are three different, at minimum of three issues, but confidential information in my books is business information, customer lists, pricing, different things that you only get access to as a customer of the provider and vice versa. That's confidential information. Historically, there was this real practice of saying that a confidentiality breach was carved out of a liability cap. In SaaS, that's definitely not a good idea, unless you deal with it properly. So just think about it. We'll get to this in a second. But confidential information is business information. You will have provisions in your agreement that are akin to an NDA for that information. Then you've got PII that's being collected, as well as whatever data the customer's putting in that isn't PII. So sometimes that data could be, data that could subject them to a regulatory risk, or business data of theirs that isn't PII, but is demographic data or something like that. So that data you have to deal with in two ways. One, making sure that the applicable laws are being complied with. And two, making sure that you are committing to a reasonable amount of cybersecurity for that data. So these buckets need to be addressed in the agreement, whatever side that you're on. So one key issue is just to have this discussion with your own business if you're the provider, as well as if you're the customer, just teaching your team what they need to look for, especially if you're a PII heavy business. You've got to deal with these buckets. So one thing that I always try to drive home is just, yes, you have to comply with privacy laws. So you need to, be clear about the purposes for your collection, get the appropriate consents, collect only the data that's reasonably necessary for the purpose, etc. But you also have to make sure that you're protecting that data from a breach, a data breach. So it's two things. It's, yes, privacy laws impose all these requirements on you, like, getting a DPA for processing, reporting a breach. There are all these obligations in the law that need to be complied with. Then, once you've collected the data, presumably in compliance with law, the customer is going to look for, how are you keeping it safe? What are you doing? And so here's where I say one of my fundamental contract rules is no vacuums. Nature abhors a vacuum. If you leave a gap in your contract, the other side will fill it. So sometimes there was a comment about vendors who don't know about service level agreements. I agree, that's a red flag. Similarly, sometimes you'll get a client or customer that has a SaaS platform and they just want to say something generic like, will comply with data security industry standard, vague. And I find that what happens with those clauses is the other side lays down their schedule for security. And then you have to explain all the things that you don't do potentially. And this does happen. So if you are at the level of company that you're not like third-party audited, you're not SOC 2 certified, or you don't have a simple thing to point to show what you're doing on the security side, I think that the best thing to do is to actually spell out, here are the things that we do, and put them in a schedule. If you just leave it vague, you're going to get somebody else's schedule. It's going to be more than what you do in all likelihood. So huge in that process is your IT person. Legal can help express things, not overcommit, clarify, make sure that the schedule is appropriately referenced. There are legal jobs to do with it, but the actual substance of the information is going to be very much, IT driven. And then the other thing about that schedule is that someone has to be tasked with keeping it up. So that's going to be updated over time. On data protection agreements, here's another fun area for in-house counsel to add value. I view these data protection agreements as an instructions document. They're just clarifying, they're complying with applicable law. They should be limited to the data subjects that have those rights. So you've got to actually limit them. And you want to keep an eye out for any additional, if ideally you're using your own DPA that you're comfortable with. If you have to use the other side's DPA, you want to make sure that there's nothing in it that's superseding your liability caps and your indemnities for data in your main agreement. So sometimes you'll see that a provider will just provide a DPA to your sales team. Oh, we just need this signed. And in it, there's some sort of liability or indemnity language for data that you have not granted in your main agreement. So, this hopefully will get sorted out over time, but there is this catch-up process right now happening where you've had deals that didn't have a DPA, now they need one. So just watch that. That's an area that in-house can add real value. Okay, so honestly, like some of these things are maybe obvious to a lot of people, but I think it's just important to break them down and get just granular about them. It makes it a lot easier to negotiate the deal. Okay, so
hey Darlene, before you pivot to this conversation, I just want to point out to somebody asked a question and Josh asked you to help me get a link. So Meredith asked, I'm interested in finding a good source for market terms for a small SaaS company. And you're about to talk about this concept of leverage, and something I've heard you repeat is this idea that that's not normal, like that as a source of leverage. This is what normally happens. Josh, I'm going to ask you to share a link to everyone for our Term Scout partnership. I would encourage you to give that a try. But Darlene, as you make this pivot to talking about leverage and what's normal, how do you learn about what market norms are, and how do you use that in these discussions about risk management? So,
well, when you do a bunch of deals across industries, you sort of observe them. I would say what I have observed, and I can talk about it now instead of later. There was a time when there was very limited understanding about the limitation of liability. So there was just this idea of, well, of course you should have uncapped liability. Of course. And of course it should be mutual liability cap. And there were all of these sort of strange things. And I think that when we get to the discussion of liability caps in SaaS specifically, it is really almost like a law school level of thinking, like going back to first principles, thinking like, what is this deal about? What are the risks here? What makes sense from a liability perspective? And something that we say on our team is that, if you're a customer, for example, and you are using a vendor to do something with your data, you can't, by virtue of using a third party, absolve yourself of liability if something goes wrong. You have to share liability because you as a customer are choosing to use a third party. You could build it yourself, in which case you would have unlimited liability, 100%. But instead, you're outsourcing it. But you can't say to the vendor, well, because I'm outsourcing it, you have to give me 100% protection. That's not actually like just in the scheme of things. So in probably the 10 years that I've been doing SaaS agreements, I don't know, whatever the 8 years, whenever SaaS started to become a key thing, there's been a real movement in customers saying, well, it should be uncapped. If I have a data breach, it's your fault. Now there's a lot more acceptance of it's some multiple of fees. It's some reasonable amount. It's maybe tied to, from the vendor or my client's perspective, an insurance policy that they have, or it's limited to certain types of damages. It's tied to a negligent action and not just any action, for example. Sometimes people are looking for liability cap to cover anything related to the service, when really, it should be anything where it was a material breach or negligence only. It's not really covering, anything, but you see language like that. So I do think over time, looking at a lot of deals, you see where the market's going. Your sales team is a great resource. A lot of sales teams that we work with do use Term Scout. Actually, that's a place that they go. You can see some of the major platforms that have their terms public. You can check those. You'll note that obviously the bigger platforms are going to have more bargaining power. And so in those early days, you'll manage the caps differently than once you have more bargaining power. Mike, interrupt anytime if you want me to go into questions, but I'm going to just
yeah, go ahead, please.
Jump into the next bit. Why don't I just do my key points on indemnity and key points on limitation of liability, see what's left over in the questions once that's done. Does that work? Okay.
Yeah, that'd be great.
All right. So there was a let's talk about reps and warranties first. So there was a question in the chat about, what's the difference between rep and warranting something versus just saying you're going to comply. And there's no magic to this. The SaaS agreement is like a puzzle. It really is. All of the different pieces go together. So if you have a $5 liability cap on all damages, direct, indirect, no liability for indirect damages, $5 cap for direct damages, you could probably rep and warrant a lot of things, subject to laws on warranty disclaimers and permitted things that you're allowed to disclaim. It's a puzzle. So what you promise is what you're willing to grant a remedy for, or what the law will grant a remedy for. So I always think that you want to rep and warrant as little as possible, frankly. So a rep is something that you're saying is true on the day of the agreement. So you can rep that on the date of this agreement, there's no viruses that we're aware of in this product. Not that that's particularly relevant to SaaS, but anyway, you make a rep that we're in compliance with law as of the date of this agreement. A warranty is something that's going to be true over time. So with your warranty, you're basically saying, here is what is going to be true in the future. So you have to be really careful when you say what you're giving. And a lot of large providers will ask for so many reps and warranties, like a rep and warranty of compliance with law. Again, I look at what they're asking for, and then I look at what the remedy is if I was in breach. Those two things together should tell you whether you can agree to it or not. If it's something, as long as the damages are capped, sometimes people try to carve compliance with law reps out of a liability cap. I would push back on that when acting for the provider. Again, back to this sort of premise that everyone has some risk in a SaaS agreement. But when you're talking about these reps and warranties, you want to be really clear. You warrant only what you're really willing to warrant. So a simple one that I think everyone can agree to is that you warrant that you will make sure that your technology is being monitored so it doesn't wreck someone else's technology using industry standard and a commercially available software, something like that, something minimal. Then you might warrant that you comply with your documentation, and that means that the lawyer has to be aware of what the documentation says. So if you're not, then I wouldn't give that warranty. But again, playbook allows you to have that discussion early, look at all the documents, decide how you're going to deal with it. So when you're putting in reps and warranties, you do need at that point to indicate what the remedy is going to be. So I would typically say if you've got a warranty for performance or something like that, you want to tie it to a repair or a replacement or a refund of a part of your fees, and preserve your rights to terminate if you can't fix it. That's kind of how I look at reps and warranties. I think like, that's where the performance stuff goes. And that's where the remedy for the breach happens. So you've got your service level agreement that talks about uptime. It maybe gives you some credits against your fees if the uptime commitment's not met. In your service level agreement, you say, that's my service level commitment. This is your remedy, service level commitment or refunds, credits. In the rep and warranty, you say, if there's a warranty breach, your exclusive remedy is repair, replace, refund 6 months of fees, something like that. Then, and that's your exclusive remedy. Then we get down into indemnities. So I'm not going to talk, you could say a lot more about reps and warranties. That could be its own webinar. But let's fast forward to indemnities. Just mindful of time. Okay, so really key points. We can be very basic. Some of you will know all of these points. Some of you will know half, but just for reiteration purposes, indemnity is only for third-party claims. No matter how much elbow grease is expended by the other side trying to get you to agree to an all claims indemnity, it just doesn't make sense. It's basically agreeing to pay for someone else to sue you for a number of reasons. So, really avoid an all claims indemnity. The point of an indemnity is if someone else sues you for something we did, we will cover you. And so in SaaS, I think that in the playbook, you could say, if the other side asks for an all claims indemnity, our position is a firm no, 100% firm no. And if they do require an all claims indemnity, maybe your step back position is, all right, you can have an all claims indemnity, but there's a cap of some small amount if it's not a third party claim. Like, you've got to try to wrangle through that one, but a firm no is generally the correct answer. Second thing is, when you are a SaaS provider, I believe back to this like nature abhors a vacuum, and so does a contract. If you don't put any indemnities into your SaaS agreement, again, the other side will dump their preferred indemnity clause in there. It will be harder to negotiate that clause. So I believe that a SaaS provider, going back to the original risk calculus, an IP indemnity makes good sense. As the vendor, SaaS provider, you are the one who is in charge of the IP. If you don't stand behind your IP, it's not clear to me, and I don't know how you argue with the other side that they are responsible for your IP. Similarly, I don't know that you would want them to defend a claim that pertained to your IP. You kind of want to keep that right to yourself, right? Like that's a key piece. So you can, I think, generally assume that the customer is going to ask for an IP indemnity. At the playbook stage, you can suss out whether the company is okay with that. I have been involved with clients where the board would not give any indemnities, zero. And it really does stop a lot of deals when the other side is going to be using your IP. So careful when it comes to, or at least just make them aware that that's going to make deals very hard to close. And again, maybe you can reduce the organization's time spent on deals by getting that point up front, but it's a really tough one. That's the only point that I would say has led to a lot of deals not closing in my time. Like if there's ever like a consistent point where it was like we could not get a deal closed, it was SaaS customer or mobile application customer, tech customer, where the vendor would not give an IP indemnity. So, every company has to make their own decision, but people are looking for that. You can limit it. So you can limit it to territorial IP. So only IP protected in US or Canada. You can limit it to a time. So 1 year after the termination of the agreement, things like that. They won't always fly, but there are ways to limit the indemnity. You must, if you're going to agree to the IP indemnity, people likely know this, but you want to carve out the things that you would not indemnify for. So combinations of third-party products, situations where the customer's misuse of your product or use outside the authorized guidelines caused the third-party infringement claim. There are a bunch of ways to carve out things that you won't indemnify for. That's a way of narrowing your indemnity. Another way to narrow your indemnity is to indicate what the other things you can do are when you get a claim. So instead of just having it say, I will indemnify, yes, that will probably happen, but also say, and if we get the claim, we can mitigate our damages. We can replace the infringing component. We can terminate if we can't replace. We can substitute. You give yourself some outs. So if you're on the hook to indemnify, when I say I think it's something people are looking for, I think that's right. And I think as a customer, you would want an IP indemnity, obviously, because of the flip side. But there are reasonable carve-outs, and you can find out. I think generally speaking, I don't get a lot of pushback on those carve-outs. That's not an area. If you put them in, it's not a big area of negotiation. Where the real meat of the indemnity discussion comes up is in the cap. Is it capped? Is it uncapped? So before I get into that, actually, the one other thing, if you're going to give an IP indemnity, indicate in the contract that it is the sole remedy for a third-party IP infringement claim. Because what you don't want is to have to fight the third-party infringement claim and have a contract breach argument. So back to this rep and warranty issue, something that you'll see a lot as a request from a customer is a rep and warranty that this SaaS product does not violate third-party IP. If that is a rep and warranty that you give, the remedy in the liability cap is going to kick in if there's a third-party claim. So not only are you on the hook to cover the cost of the third-party claim, you're also on the hook up to the liability cap for the damages you've agreed to in between you and the other side. So careful when agreeing to stuff in reps and warranties. It's reasonable to cover the third-party claim. It's not necessarily reasonable to have two remedies. Again, bargaining power comes into it, but that's the first position. Okay, so make sure that that indemnity is the sole remedy. If you can get that and you have the rep and warranty, here's the puzzle bit. Arguably, it's the only warranty or the only remedy. Okay, so the other thing to do is to make sure that you've got your processes around the indemnity. If you're going to grant one, put in some processes. How does it work? What happens when the claim comes in? All that stuff. That needs to go into every contract if you're agreeing to indemnify. And then what I think is even maybe a better idea is to actually also have a process for if the parties dispute whether the indemnity applies. So from the vendor perspective, you don't necessarily want that because you want to just be able to say, sorry, doesn't apply, it was a combination. But from the customer perspective, you want to be able to say, hey, if we disagree on whether an indemnification obligation kicks in, we need to have this go through our dispute resolution process or something similar. I'm very cautious about granting other indemnities other than the IP indemnity as a SaaS provider. You do get data protection IP, data protection indemnity requests. If you end up in that scenario, I do think that it's got to be, again, very limited what you're agreeing to, ideally, and very much subject to a cap. So although indemnities can sometimes be uncapped, if you're going to agree to something other than an IP indemnity and you're the vendor, there should be a cap. All right, so puzzle piece. The indemnity, you can grant all the indemnities in the world if your limitation of liability includes any expenses tied to indemnification and is capped at $5. So just to use a ridiculous example to make the point. Limitation of liability, typically, this is an important point, you have to draft if you want it to cover your indemnity. It needs to be really clear in the contract that the limitation of liability covers costs and expenses tied to an indemnification obligation. That's a key piece. So, big point, I guess, for everyone. If you want to have the indemnity capped under the limitation of liability, cap it with contractual drafting. Often the customer will be looking for an uncapped indemnity, and that's where the business decisions come in. I think the only thing that is traditionally uncapped when it comes to an indemnity is the IP indemnification. I think the market has settled on most of the time. Otherwise, you can get a cap on the obligations, depending on bargaining power, to indemnify for other items in the contract, or you should at least try your very hardest to get them. Some other key points about the limitation of liability, just for going back to what I said at the beginning about these caps, I think it makes perfect sense that there is an imbalance in the cap on liability between the vendor and the customer in this context. So you'll often get to the table and the other side is like, oh, we want a mutual cap on liability. And to me, that doesn't necessarily make sense for the reasons that I explained at the beginning. One, the customer does not get to put all the risk of their choosing to outsource on the SaaS provider. It needs to be shared. Two, the vendor has to be able to offer a one-to-many solution in SaaS in some reasonable way. If they have uncapped liability to all of their customers, they can't be in business. So this is the understanding on which the SaaS world is based, and we can accordingly use that to inform all of these negotiations that we're going to have. So just a couple of key points about limitation of liability. Exclude caps that aren't permitted by applicable law. This is just a basic one. You don't want to have your clause cap damages, but not say specifically, we're not intending to cap, damages that are not cappable under applicable law. This question of indirect damages, I think many of us would be forgiven for saying nobody wants indirect damages. Let's cap it for everybody. Let's just say mutually, nobody can secure indirect consequential damages. So there's a good reason to cap those damages. That's the reason is, going back to law school, not foreseeable. So we can't be responsible if, because of something our SaaS did, your building burnt down, just as a ridiculous example. That's the reason behind the cap on those types of damages, is they're not foreseeable. So yes, it makes sense to exclude those in most cases, but for the SaaS provider, you need to cap the customer. You can't be on the hook for the customer's indirect damages, consequential, special, punitive, etc. That's a clear cap. I think that generally can be negotiated on the vendor side. But the vendor also needs to make sure that it can recover indirect or consequential damages if certain things happen on the customer side. Customer steals the vendor's IP, for example. Customer doesn't pay their bills, walks away, and because the vendor was serving that customer for a full year with their professional services, vendor lost a year with another customer. You want to say, if the customer materially breaches, ideally, again, you can secure these types of damages. Interestingly, I don't get as much pushback on that as I, would expect. Sometimes you do, but I think people understand that if the customer is misusing the IP or they're using something outside the license permissions, that it's reasonable that the provider retain the rights to get whatever damages, because the provider might not have direct damages that are provable, but loss of business revenue will be obviously a result of a lot of the things that would happen. So just be cautious about that one. Okay, so back to caps. I think there was a question about this. Liability caps should apply to direct damages for sure. I would love if it was just a monetary cap, like damages are capped at, and you see this in terms of service, $100 or $20. In a service agreement, usually it's something like the liability for damages under this agreement is capped at 6 months fees or 12 months fees. So just be really careful in that. I've seen some really wild agreements and disputes over the years. Sometimes they'll say damages are capped at fees paid. So that is actually, there are a lot of questions that raises, like, what if I don't pay my fees or haven't paid for the last year? Maybe it should be fees paid or owing under the contract in the previous 12 months. It should be tied to a 12-month period. And the reason for that, or some period, but a predictable period of time, because to the point of whoever raised the point about bad contracts, sometimes you wade into a contract 10 years in, and 10 years ago, there was a fees paid under the contract cap. And now that cap is massive. So try to keep it to either a dollar amount that the parties agree on or some reasonable period of time. I think it should be cumulative, as in that liability cap applies to everything that might happen under the agreement, not per incident. And then you always see this language, this liability cap applies to breach any theory of liability, contract breach, negligence, etc. And I think, that's key language to have in there, because the concept is this isn't just the liability cap for this contract breach. If a claim is brought in negligence, in tort, this is intended to cover it, because this is just the party's intentions. That's what this contract is. So make it clear. If you need something covered, make it clear. And then carve out willful misconduct out of your caps, obviously. And I like to define those terms, just because if you're dealing in SaaS across boundaries, across borders, just define things. If you are concerned that it will be misinterpreted, that's the way to go. Then you've had a meeting of the minds. So 1240 or 240, let's see. Should I answer a couple of questions, Mike? Or do you want me to keep?
Yeah, we can. You might be able to incorporate some of these. I got, to your point, a couple of questions about the cap. Do you tend to push for gross negligence instead of mere negligence? Question about if you're only processing non-sensitive PII, how can we frame the conversations around fee-based super caps? So we've got some questions on that. The one, back to your indemnification point, how can we keep any indemnification provisions specific to the MSA and not have additional indemnification in the DPA? So those are just some new questions to red flag for you. So I'll leave that to you. I know you've got some of these tips. If you guys have any other questions, now's the time to drop them in. Again, if we can't get to all of them now, we're going to stop here in about 9 minutes and directly address some questions. But go ahead and get those in now. Even if we can't address them all now, we'll be able to deal with them in future. That helps me understand what you need for future training. So please add those.
I feel like we need a whole Q&A session. And I think there will be a number of different answers. I mean, some of these things are going to be specific to the experiences that different in-house counsel have had. Some of them, I bet there are many answers, honestly. I will try to get to all of them, but yeah, wouldn't that be great? That would be fun also. All right, let me go through another SaaS drafting tip. A couple of these things I've covered, and then we'll just wrap up. But breach scenarios. So until you've been through a dispute with your own contract, it's hard to envision how these breaches would go. But when I talk about a SaaS agreement being a puzzle, there are so many pieces of the contract that will come in if there's a breach. For example, let's imagine a breach scenario, and suddenly it will become clear why these points are necessary. You've got a breach where you've got a customer who hasn't been paying. They've been disputing their invoices, and now they want to terminate the contract. So a couple of issues come up. One, did you have an invoice dispute resolution process? Probably not, if they haven't been paying and it's gone on for, say, 8 months. Has the client, what's been going on in that whole time? Sometimes you look into the boilerplate and you're like, one, they're saying that they don't like the product. They have a warranty issue, and they're saying it's a breach. They're not paying their bills. Suddenly you're like, well, why have we waived our right to collect? No one's been chasing them for these bills. Sometimes the company has been offering professional services, trying to resolve the issue that they haven't been charging for. In those cases, you look to your boilerplate, you find your no waiver clause. This is a really critical clause. So you need to be clear that you haven't waived any rights to collect the payment, or say that they haven't had a proper dispute for the invoice. That's an easy one. So when you think about like what could go wrong, think about the legal tools that you could have to deal with them. So much about the breach scenario is about tracking through where it will lead. So for example, I had a recent one where there was a cyber incident. The SaaS provider of the cyber solution had a warranty provision that set out a remedy. Then there was a limitation of liability in the contract and all of these other pieces. And based on the fact scenario, you had, and really you could envision the worst case scenario. That's the best way to trace these through. So what happens if company just drops the ball? So they said they would do something, they warranted, it's in the documentation. Okay, they didn't do it. I get a refund, I get a repair, or I get a replacement. If they can't repair, they can't replace, they have to refund. Fine. So once they refund, then you're like, okay, well, what else can I get? So I got my warranty refund, had this breach, they dropped the ball. Oops, in my boilerplate, it says that was the only remedy for a breach. So if you're going to take the position it's a warranty breach, that's it. That's all you got. However, if I negotiated a cumulative, all remedies, no one remedy excludes other remedies, maybe I can also argue for a breach of contract or some other remedy under the contract. So trace it through all the way, figure out what happens, and then you identify your gaps. So easier to do with a real scenario, honestly, but if you can kind of come up with your worst case scenario or apply something you've seen in another context to your own contract, that is honestly the best way to make sure you've got everything tied together in your contract. So, all right, let's go into the questions.
Yeah, let's follow through with your idea and have a Q&A. Let me try to wrap a few of these. So I had a few questions about just staying up to date on cases. Paul Shelton asked any general regulatory update. Anonymous asked, what are the best practices for cross-checking whether the language in your contract will bump into litigation based on state case law? Meredith asked, what's the best way for in-house counsel with very limited resources to keep track of court cases that affect contracts? And this gets into like, there's so much, you need to understand the business, this is negotiate terms, deal with sales, but we still have that role of we're supposed to know what the heck is going to get us into trouble. So any tips on how people can stay up to date on the substantive legal issues?
Well, I think it varies. One thing that I do, we have in Canada, all of the law firms have their newsletters that they put out. So everyone's got these newsletters with blogs. They post about recent developments. Pretty rare that a really critical case that really affects a giant issue doesn't get published somewhere. So, you've just got to track sort of authoritative sources. I attend a workshop every year put on by the Tech Lawyers Association that talks about recent developments in boilerplate, which is my favorite day of the year. And it talks about, here's a case that happened in this jurisdiction and it drives this change to the contract. And yeah, the weird thing about in-house is that we have to do that. So I think building it into your process, the toughest thing about in-house is trying to find time for all of it. So maybe assigning a junior on the team to stay up on it, putting it out to your outside counsel that you are looking to keep your playbook updated and can they help you? Things like that. Even, Law Insider probably has other resources that they want to point to, but those would be it's a bit cobbled together. But I do think you need the resources.
Well, and to your earliest big picture point, I was thinking about a post that I saw on LinkedIn where somebody congratulating themselves said that legal ops saved some company 0.5% of revenue or something. And they thought that was a big deal. And of course, they got hammered for, man, this is nothing, right? Like to this company, this is a rounding error. Nobody cares. But to your point, you do these process things not because it saves the company money. This idea of efficiency is not just to save money, but it's also to enable you, whatever practicing at the highest level of your license means. So having the time to stay up to date, hard to prove on paper sometimes, but really important. I want to revisit a question that Alex revisited. And I don't know if there's a good answer to this because legal ops is a fairly new conversation and people are not being very public. But have you seen a software that's really good at creating and managing playbooks for the contracting process? So it's not just important that they're good at it, but also that they're public with it so that we would see it. Do you have anybody in mind that you think is doing this really well?
I don't, is the very short answer to that one. But if anyone knows, put it in the chat.
Yeah, I mean, Google obviously has been very public with their legal ops processes. That's become less so since Mary moved on from Google and is now at Ironclad. But there are some companies, especially if you look through legal design, that have been very public. I think it was Boeing that shifted to a very short contract and was very public about that change. Some of our past contract teardown episodes, we have general counsel there from small software companies that are being very public about their playbook. So it's a good question. All right, what else? Do you see any others in here that you want to jump onto, Darlene, before I suggest some?
So there are some chats coming in about the contract lifecycle management. I think so one word on legal tech. So sometimes these problems are immediately like we jump to like, let's get the tech. I believe build the product first, then get the tech. And maybe that's an old school idea, but I've seen too many companies where they go and make this big investment in the legal tech without having the time to do the work, to do all the inputs to the legal tech. And then it's just a piece of bloatware that no one's using. So if Ironclad is working really well, it's probably because the in-house lawyers have done the good work to get it to do what it's supposed to do. And if you have the resources to do that, then that's great. But I do think that a lot of the work we're talking about today is sort of pre-legal tech. It will still work without legal tech. I guess that's the simple way to say it. And then if you have such scale that you require tech, get the tech, 100% get the tech. I'm not anti-tech, but I am anti-convincing your CFO to buy the tech and then having it not be used because we didn't do the preliminary work, which can happen.
Yeah, back to my favorite piece of legal tech is the Post-it note, right? Just figure out what a Kanban board is, figure out what your workflow is. It's really hard to standardize your workflows until you've, or document your workflows until you've standardized them. All right, what else? I don't know if this question is motivating to you, but I got the question for retail SaaS, and you can define what retail SaaS means. How do you handle liability associated with breach of customers' credit card information, passwords, et cetera? I think you got into some of that higher level of security, private information, but any thoughts on that one?
Yeah, a couple of things. If you're the vendor in a product that is collecting really sensitive information like that, you've got a higher responsibility on the cyber side for sure. You've got a higher, if you're actually collecting credit card information, you have to comply with all of the PCI standards. So a company that's actually dealing with really sensitive PII is going to have really robust provisions. And I think you're going to find that people who are your customers are going to be asking you to take on some higher degree because the risk to them is greater. But I don't think you take on all of the risk. As I said, you can't be so you can't be putting your data into somebody else's, or I guess maybe by retail SaaS, do you mean B2C? Actually, that's probably what you mean.
Yeah, that was my question.
So I guess sorry, let me back up a second. If it's just an end user terms of service, I mean, you basically limit it in your terms of service would be probably my short answer to that. But we can talk more about that. But in a SaaS agreement where you're dealing with a provider that collects that information or doesn't, I actually put in my agreements that the customer will not put sensitive information into the SaaS product without our permission. So we have customers that for whatever reason are collecting all kinds of data, but you as the provider want to know what's in there so that you can appropriately comply, make sure that you've got all the right standards. So yeah, credit card information, you have a whole bunch of regulatory obligations, never mind what your specific breach obligations are to the customer. But presumably your contract with the customer is going to say you have no liability, and then you're going to have a ton of liability in the regulatory context. So the contract can only do so much.
Yeah, I'm going to unsettle people by sharing a different screen that I've been sharing. I want to go actually over to the actual playbook. And the reason is for one of these questions. As a client for SaaS, can you give an example of what you would playbook as preferred versus acceptable versus unacceptable for IP infringement? And I'm sharing this with you, and I'm sorry for making you dizzy as I scroll down. But so that you can see that in this workbook, you can see that we've got the essential elements of a comprehensive playbook, and Darlene and Adam Long worked on this quite a bit. And you can go into this sort of framework, these different formats, as Darlene talked about. But you can see how, why people put this in a spreadsheet versus why you would use something else. But Darlene, maybe you can give an example of IP infringement specifically. How might you change this preferred, acceptable, unacceptable kind of thinking for that particular example? How might you think through that?
Okay, I just want to see the question.
Sorry, it's from Anonymous at 12:59. Or sorry, 12:59 my time.
Sorry. So what I would put in the playbook, these are simplistic examples for the most part, but when it comes to IP infringement, I would never rep and warrant as between the parties that there would be no breach of IP infringement. You would do the opposite. In your warranty disclaimer section, you actually say, we do not warrant non-infringement. Most warranties would say that as an exclusion. So you don't want to say, no one can warrant that there's not going to be an IP infringement claim. All you can do is say, if one comes, we will indemnify you for that claim. So that's a pretty critical distinction. So if the playbook, if the customer is concerned about IP infringement, I would say IP infringement's a concern, preferred position, no rep and warranty, indemnity only. And then, my preferred would be that the indemnity is capped at fees. Of course, that's not always achievable. And in reality, you would probably be on the hook to pay whatever it costs to defend your IP. But I would think through the issue that way. So, if there's IP infringement, what happens? So you don't get sued by your customer. They don't get damages because you infringed IP. Instead, you go the indemnity route and you make sure that the IP indemnity has all the limitations on it that we talked about.
Let's ask one more question. I think this might be a bigger picture, and then we're going to get into some details. I'm going to ask make a request of you all, and then also explain when recordings are showing up and other access to information. So I got this question, and I think it's interesting because of trends. Lately, I've been seeing agreements in which the SaaS provider attempts to disclaim any implied warranty of non-infringement. Is this becoming industry standard, or at least more common? What are your thoughts on sort of these kinds of trends in SaaS agreements?
I mean, I guess sort of this is where these types of discussions are helpful, is just to, when you really think about the principles of what's happening instead of the sort of lawyer reaction of like, liability. If you think about the principle, you can't warrant non-infringement. How can you warrant that? You could maybe say, as of the date of this agreement, we've not received any claims. You could represent that. You could say, today, I'm not aware of any claims. You cannot warrant that, especially a lot of these agreements are global. You can't say someone out there is not going to have an issue with this, because IP infringement claims are not always obvious. It's not always that and frankly, a lot of smaller companies don't have the resources to check. So again, you're not warranting. I think it is standard to have a warranty of non-infringement, to exclude a warranty of non-infringement. So you're not warranting that it doesn't infringe. Oh my God, this is why we're all going crazy. Anyway, so that warranty is standard to exclude, but the indemnity is where I would focus. So again, back to the puzzle, it's, maybe you accept it somewhere, but you get what you need somewhere else in the agreement.
All right. Well, we're going to wrap up, Darlene. Thank you. I'm going to ask for make one quick request for everybody who's joining. When you leave this session, you're going to be prompted to answer some questions from Zoom. And you're also going to get an email asking some questions. In that, I'm going to be a little transparent. We are trying to figure out how to help you. This is a really interesting audience. It's large, it's international, it's diverse, lots of different experiences, a lot of different perspectives, which is awesome. But it's also really difficult to make one thing that makes everybody happy. And so I'm going to ask you to tell me what makes you happy. It can be it could be literally just what makes you happy. So if you can respond to the survey that's coming out, tell us a bit about you. Tell us about what interests you. I'm also going to ask for some feedback on this specific event. If you could give us some glowing reviews, tell us how wonderful Darlene's speaker in the background is. My hair, I got a haircut yesterday. It's sort of a exercise in futility, but I did it. And I want to know why you left it. If you could give us some positive reviews, that would be helpful, or negative reviews. Teach us about how we can help you better. Darlene, for people who want to reach out and learn more about you and your practice, what's the best way for them to connect with you?
Interalia-law.com is our website, and my email is up there, as is I think all my contact info is up there, and you can see our whole team on there. I am not the only SaaS lawyer on the team, and there are probably, as Mike says, my goal at Interalia is to surround myself with smarter people. So we've got specialists in all the different verticals. Although we can't say specialist, so erase that.
Yeah, there's rules. Canada, just forget that. No, I appreciate you, Darlene. We certainly surrounded ourselves with smart people today. Y'all have a great day. Please respond to that survey, and we'll see you at the next training. Thank you, guys.
Awesome. Thank you. Thanks for the invite.